Madam Speaker. Thank you very much. I have listened with interest to the contributions from the members on the other side. And I hope I can be brief in the response that I will make without doing any disrespect to the several remarks that have been made by the honourable members. I understand essentially that each of the members for the other side who has contributed to this debate support the amendments which I bring to this honourable House today. But they have expressed concerns about a number of matters which I think it is my responsibility to respond to, albeit briefly. And if I were to start with the comments which have been made by, first of all, the remarks which have been made, first of all, by the member for Tabaquit, which has been repeated and adopted by other members with reference to the amendment to Section 48 dealing with the terminology without delay and the suggestion that there is an unnecessary lack of clarity and or legislative precision in the use of the term without delay. May I just say by way of response, Madam Speaker, two things. Without delay is introduced by the word shall in that amendment, and those of us who are familiar with the language of the law will understand immediately.
The owner of the device is not in here. Please continue.
Thank you, Madam Speaker. Those of us who are spend some time reading legislation and having to assist in other places with the interpretation of the legislation would appreciate immediately that the introduction of the words without delay by the prefatory term shall introduces an imperative in the word shall. And then when we look at the Interpretation Act, Section 23, with reference to the term without delay, Section 23 tells us that where written law requires or authorizes something to be done, but does not prescribe the time within which it shall or may be done, the law shall be construed as requiring or authorizing the thing to be done without unreasonable delay, having regard to the circumstances and as often as due occasion arises. Taken in context, what that means is that the draftsperson of the amendment to Section 48 under consideration by saying shall without delay in respect of an obligation that is imposed on the Commissioner of Police understands that that office of Commissioner of Police must be given a level and a measure of discretion to discharge his or her functions, but understanding that it must be done without unreasonable delay. So there is no lack of clarity in the language shall without delay in doing that which the amendment empowers him to do. If I may move to the other point made by the member for Tabaquit, she says you cannot sell the honourable member, I beg your pardon, the honourable member says you cannot sell the bill as a solution to the public, the population, as there are so many other things that remain unfixed. But we have to appreciate, Madam Speaker, that this is a work in progress. The government of the Republic of Trinidad and Tobago, on which I have the privilege to serve, continues to bring laws to protect different categories of persons in our population. Laws to protect the vulnerable in our society, example, child marriage, domestic violence, bail, trafficking in persons, anti-gang, evidence, firearms, children's court, family and children division, criminal division, pepper spray legislation. All of these are a holistic approach to seeking to protect the vulnerable in this society, and it cannot be dealt with in isolation. So I do not accept the criticism that the bill is being sold as a solution to the population while many other things remain unfixed. The criticism was also made that consideration needs to be given in relation to the burden on the Trinidad and Tobago Police Service by placing timelines in the legislation. And one of the things that we have to appreciate immediately, that the Commissioner of Police is given explicit responsibility under Section 48.3 of the amendment of the Act to ensure that the website is maintained and the information is recorded in accordance with the Act. And in point of fact, one of the things that we are cognizant of on this side, certainly, is that the Trinidad and Tobago Police standing operating procedures on sex offender register and sex offender website are contained in Departmental Order 81 of 2018, so that the police have seized the nettle and have themselves passed their departmental orders to encourage their membership and to undertake the burden which this amendment and this new legislation has brought on them. So I think that, and I commend them for being very much up to the task of ensuring that the vulnerable are protected under this legislation. We heard also from the member for member for Chaguanas West, I beg your pardon and I apologize, who spoke of the fact that a person's gender on the website has far-reaching consequences. And I stand subject to correction, and I apologize to him if I've misunderstood him, the honourable member, but I would say that the gender, in answer to the honourable member, the gender of the sex offender is basic information that the public should have access to, as there are both male and female sex offenders in our society. This information helps to identify the offender. We, in the drafting of the legislation, have looked at other jurisdictions, including the United Kingdom, New Zealand, and Australia, where the information contained in those registers are far more detailed. We could have included more details, but we put that which we consider to be digestible for our society in the first instance. If the gender changes, the offender has a duty to inform the Commissioner of Police, who has a duty to update accordingly. There's a criticism as well from the honourable member for Chaguanas West with respect to, or concern rather, with respect to Section 47.2, Schedule 3, whether this information should be well known, that is to say, the information in Schedule 3. Well, a balance has to be struck, I say in answer. A balance has to be struck between information given to the public and the sex offender's right to privacy in order to prevent victimization of the offender or indeed vigilante fugitive justice. We have to be careful when we pass laws that we strike the right balance and we do not pursue laws in needless condemnation of persons' rights, even while they are being found to be guilty, but they have rights of appeal and they have other rights of redress. So we have to be careful to strike the right balance, Madam Speaker. The member for Chaguanas West also spoke to the United States Megan's Law and Sarah's Look, which takes a more conservative approach and questions whether there's a need to give greater information to the public. And we say at this point there is no need to give greater information to the public, having regard to the wealth of information that is available on the National Register, which is under the surveillance of the police on an updated basis, and the National Sex Offender website, which contains details and which are, in limited terms, available to the public. So we think that the adequacy of the information and availability to the public serves the present balanced purpose that we seek to achieve and to serve. And the question has been asked by the member of Chaguanas West as well, whether members of the public should be notified. And we say in answer to that the sex offender website is notifying the public. They are also to simply log in and view the website at any time. Abuse of the information on the website will be an offense. We think that that is an adequate measure and that the public is sufficiently notified. Then there was, I beg your pardon, there was some concerns expressed from the member for Maruga Tableland She says that the legislation and the initiative of the government lacked educational programs within rural communities. Well, if I understood her correctly, I say that that is irrelevant to the current bill being debated. She says that the honourable member says that the bill is to correct, is meant to correct, to address corrections, and that it is sloppy work by the government. We are not all perfect, and as we progress in life, we will acknowledge with the courage that it takes to recognize that there is room for improvement, that there is room to come back to this honourable house and to improve the legislation as the circumstances dictate. And that was the basis. That was the basis on which I opened before this house today, madam. I said that we are here today to improve on a continuing vigilant basis the legislation that it is our privilege to bring to this house to improve the conditions and to protect the vulnerable. So it is not sloppy work of the government. It is an encouraging of a vigilance on our part and on the part of all parliamentarians, and we will welcome contributions, positive, constructive contributions from all members of parliament to ensure that as we work towards bettering the society for our citizenry, we continue to keep our work under review to improve at every step of the way. I think the member also said that we need social outreach and counseling for children re-entering the school environment. That is a laudable initiative, but regrettably I say it is not relevant to the subject that we are here to debate this afternoon. And therefore I don't think I need to answer that in any further detail. And then the members for St. Augustine and Couva South also made suggestions about the without delay. I've already addressed that. I don't think I need to address that any further. And therefore, Madam Speaker, I beg to bring my contribution by way of reply at this stage to the end, and I beg at this stage respectively to move. Thank you.